In the Proposition 8 case, your friend of the court brief centered on standing. Could you tell us, as succinctly as possible, what the argument is?
Sure. The core argument of the standing brief is that Proposition 8 sponsors who purport to be offering the government's interests in defending Proposition 8 are no more than private citizens who have the sort of generalized interest that doesn't get them into federal court, right? So we argue that they do not have the kind of concrete and particularized interest that long settled jurisprudence requires for access to federal court. That's Article 3 of the Constitution that says, has been interpreted to mean that the only people who can invoke the jurisdiction of federal courts are those who have a concrete and particularized interest in a case. Proposition 8's promoters care a lot about Proposition 8, but they don't have that interest because they are sponsors, right? They went through the initiative process. The initiative process doesn't give them any special right to defend an initiative after it has passed.
Right. And if the High Court agrees with that argument, then that means that Judge Walker's opinion stands. Is that correct?
Right, so if the Supreme Court agrees that Proposition 8 sponsors don't have standing, the case has to leave the Supreme Court, right? The court has to dismiss the case. And the reason is that California has not defended Proposition 8. So there's nobody defending Proposition 8 from the government right now. The only group that's trying to defend the Proposition 8 proposition on the government's behalf are the sponsors. So if the cert petition is dismissed, then Judge Walker's opinion is the one that stands. And I want to make just one other point, which I call Article 3 double dipping.
Okay.
And here the idea is that Proposition 8 sponsors are saying that they are standing in for the government and asserting the government's interests. But in fact, the government has taken a position in the case. The California Attorney General, who is the highest chief law enforcement officer of California, took the position in responding to the plaintiff's complaint, the same-sex couple seeking to marry, their complaint, saying that he agreed that Proposition 8 violated their constitutional rights. So the only way for the sponsors also to assert the government's interests is if the government can kind of bifurcate its interest and have some on both sides, which doesn't seem right under Article 3 or more generally.
Talk a little bit about the DOMA case, U.S. v. Windsor. You also filing a friend of the court brief in that case, and here the brief is centering on equal protection. Can you give us a little bit about what your argument is in that brief?
Professor Nan Hunter of Georgetown Law School and I have filed an amicus brief in the Windsor case, making the argument that the court's equal protection law, while heading in the right direction, has often been murky, and it is time to articulate a clearer framework for equal protection review, especially given the pluralistic nature of our country, growing ever more diverse, with increasing varieties of discriminatory classifications. And the court needs a clearer, more straightforward way of analyzing discrimination than the kind of suspect classification versus rational basis review framework that prevailed in the 20th century. And the argument we make is that when you look at the court's jurisprudence, its real concern is with classifications that are invidious. That is, when the government draws lines and singles out a group where the indicators are that there was something wrong in the choice of the group, either because the group has been discriminated against historically, as is true for gay people in the case of DOMA, or because of the particular set of circumstances. So for example, as has happened in a number of cases, the government has discriminated against out-of-state truckers in favor of in-state truckers, or more recent residents of a community as opposed to long-term residents of a community. In both of those cases, when a state puts a burden on the more politically vulnerable group, we have to ask, is the burden justified? And so the point of the brief is to give the court a framework for thinking about that. And certainly in a case like DOMA, where you have this extraordinary sweeping denial of rights to same-sex couples, and the denial of rights is to a group that has historically been discriminated against, we have an especially serious concern, and the court should look especially seriously, and as we hope and expect, strike down the measure.
If in Windsor, the High Court, agree with this argument, what happens, and a lot of folks ask this here today, to the 30-some states, 38 I believe, that have either constitutional amendments or laws on the books that say gay men, lesbians and gay men cannot marry. Do we know what would happen then?
If the U.S. Supreme Court strikes down the Defense of Marriage Act in the Windsor case, all that happens is that DOMA is invalidated. Nothing in that decision says anything directly about the 38 states that currently discriminate against same-sex couples in marriage recognition. Okay. Now, depending on the court's analysis, there are ways that the analysis may be used to help make arguments to urge that other courts invalidate those laws. And I think also the court striking down striking down the Defense of Marriage Act may help send a message to states that they may want to reconsider discriminating, right? Having a discriminatory line, having one marriage rule for same-sex couples and another for different sex couples. But there's nothing that comes out of a DOMA ruling or a DOMA invalidation that automatically or immediately affects the states that have laws that discriminate against same-sex couples.